This is Mike. Mike is a formidable art thief. Mike just recently stole this painting from the Forest Museum just across the street from his home. Mike got away without any camera or person seeing him. The policemen knock at his door, asking if they can come in and search his house. Mike denies them entrance, not wanting them to find the painting. Mike doesn't want to get into trouble, so he doesn't do anything drastic to stop them, as they push past him and step inside. The policemen find the painting, and they arrest him. A couple of weeks later, Mike is released with no charges. The art community and the Forest Museum are furious and confused, demanding justice. In this video, we will explain why Mike was released. The Fourth Amendment in the Bill of Rights was very important to the Founding Fathers. As James Otis states, quote, "Now one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle." End quote. They felt that the King of England had infringed on their rights, so when they drafted the Bill of Rights, they were sure to include something to protect the people against unreasonable searches and seizures in their houses. The Fourth Amendment states, quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." End quote. The way that the Fourth Amendment achieves this is through warrants. Law enforcement must receive written permission from a court of law to lawfully search and seize evidence. A court offers permission via issuing a writ called a warrant, which warrant is necessary to enforcement to enter someone's property unless they receive permission to do so. Granted some exceptions. We will take a brief look at 6 court cases clarifying the Fourth Amendment and why the evidence against Mike couldn't be used in court. First, we will take a look at Grau v. U.S. in 1932. The police had acquired a warrant to search a man's house in search of illegal alcohol. After searching in vain through the house, they extended their search to his shed, where they found the alcohol. The plaintiffs challenged this, and eventually the Supreme Court ruled against the police, publishing a new precedent stating that the police cannot search wherever they want. They must remain within the particular bounds that the warrant grants them. About 20 years later, the police again entered a man's house with a legal warrant. Immediately upon seeing the police, the man swallowed the pills that would incriminate him. In response, a nearby policeman struck his hand down the man's throat, and when he found he couldn't reach the pills, the policeman sped the criminal to the hospital, where they pumped his stomach, forcing him to vomit and retrieving the pills. The manner of retrieving the evidence shocked some, and soon the question of whether the evidence could be used to incriminate the man rose to the courts. The Supreme Court ruled in Rochin v. California that the police officer's method of evidence retrieval shocked the conscience, and therefore wasn't legal, setting a new precedent that the police have some limits to their method of gathering evidence. In 1961, policemen entered Mapp's house without a warrant. They found no evidence of the woman being a bomber, but found illegal pornographic material. The question in court was if the materials were protected under the First Amendment. Did they fall under the category of freedom of expression? The Supreme Court ignored the question and ruled against the police in Mapp v. Ohio, which resulted in the pivotal exclusionary rule, which, as stated, in that all evidence that is acquired illegally must be thrown out, no matter the scale of it. But this rule is not absolute. As the world moves forward, people notice flaws in previous rules. We take a look at some exceptions to the exclusionary rule. First, let's say that Mike is seen running away with the painting, and the policemen are chasing him, and see him run into his house. In this case, the policemen were in hot pursuit of Mike. Because of the precedent established in Borden v. Hayden, they do not need to get a warrant to enter Mike's house. One must keep in mind that when in hot pursuit, the policemen would have to make sure the search remains narrowly tailored, and they don't go looking in drawers that clearly couldn't hide Mike. In 1982, another exception to the exclusionary rule came through Washington v. Chrisman. To explain this doctrine, we will return to Mike's initial situation. He is safe at his house, and no one saw him take the painting. Let's say Mike loved the painting so much that he put it up in his house, in the entry room by the door. The police knock and see it right away, and arrest him. Does this evidence apply to the exclusionary rule? The Supreme Court ruled that the evidence is free to be used in court if it is in plain view, adding another exception to the rule. The last exception came 2 years later when police, with a warrant, entered someone's house and found the incriminating drugs they were searching for. Later on, the warrant was found faulty, and the question of whether the evidence could be used in court was impossible to answer. The Supreme Court ruled that the evidence could be used because the police were acting in good faith. The officials thought that they had a valid warrant, and therefore they were allowed to use it as such. As we take a look at all of these cases, we see the importance of the Fourth Amendment and the exclusionary rule. It sets a check on the police and keeping them from getting too powerful, and therefore keeping the people safe. Now, if we return to Mike's situation, we can see that he was released because of the exclusionary rule. The police entered without a warrant, jeopardizing whatever they found. Lucky Mike. Hopefully he learned his lesson.